Welcome back to the Legal Alternative Podcast with me, Sam Pawson. Joined as ever by Nils. Nils, how are you?
I'm good, you?
Very good. Very good. Getting a bit cold. So we have to do the weather chat. So yeah, getting a bit cold and bleak and rainy. But no, generally very good, very busy. Another action-packed podcast, bit of a discussion for me, but I think you're kicking us off first.
Yeah, so again, just some practical points to make in terms of more immigration law changes.
Yep.
Really changing at a very, very fast pace. Mid-month, so on the 14th of October, another statement of changes to the immigration rules was published. Some of them are quite niche. So there were some changes around the visa national list, which involved individuals from Palestine, which they recognise as a state now. A change that will affect some of our clients from the 8th of January. Initial applications under the skilled worker route will require what's called level B2 English. So if English is not your first language, so if you're not from Australia, New Zealand, United States, and you need to take an English language test, minimum level are going to be B2. But if you've already got immigration permission granted, so leave the level at level B1, which is the previous, you'll be able to continue on that that level when you're seeking an extension, if you're seeking an extension. Some changes to the high potential individual route. So a list of eligible institutions in that route will double, but there's going to be a cap on that. Only 8,000 applications will be introduced, and some changes surrounding graduate route visas. They'll be granted for 18 months instead of 2 years now. If you're a PhD student, PhD graduate, that will be still 3-year period. That will affect some of our clients because we've used that quite a bit in the last 12 months. Perhaps the most important change, rather, because it comes down to pounds, shillings and pence, a lot of these things, immigration skills charge is going to increase. That was announced on the 17th of October, subject to parliamentary approval. It's going to increase by 32%.
Right.
So big hike.
Yeah.
16th of December, that will take place. So immigration skills charge, in most cases, has to be paid every time a company sponsors a migrant. And that would be under whether skilled worker or many of the other routes.
Yeah.
So if you're a small company, from the 16th of December onwards, £480, an increase from £364 for any period of employment to 12 months, and then £240 for each subsequent 6 months. So it's still £480 a year, increase from £182. Large companies, £1,320 for any period of employment up to 12 months, and then £660 increase from £500 for each subsequent 6 months period on the certificate sponsorship. So that's gone 132 up from 1,000 and 660 up from 500. All part of the general trend. I think we've discussed this lots of times this year. All part of the general trend in terms of what the government's trying to achieve.
Yeah. Which is my point. I think it's more of the same. It's more costly for shorter periods of time, and ultimately harder entry requirements.
Yes.
So it is more of the same.
Yeah.
Obviously a political narrative behind that in terms of what they're going to achieve, but important obviously updates for our listeners to know. It's yet another cost. So I think a lot of the things we're talking about, the similarity is this is all workforce planning. This is how much of the it's this piece is costly, so you're needing to get that right. If you don't, it's just wasted cost down there.
Exactly.
So interesting to know. In terms of my update, Nils, what I wanted to talk about today, I get you to chip in. It's to be honest, it's as much your area of law as mine. For our regular listeners, last week I talked about tribunal fees and the potential introduction of tribunal fees, and what we see at the moment is a very difficult time in the employment tribunal in terms of capacity and the challenges that's going to presents at the moment, and then potentially even more so with potential changes from the Employment Rights Act bill, which as of speaking today at time of recording is going through its second reading. So I'm imagining by this time next week on the podcast we'll have a lot more to update legally. So what I wanted to talk about today and get your view as much as mine is on the use of AI within the judiciary. Because what's prompted me this is actually an article that's been put across my desk where the Master of the Roles, Sir Geoffrey Vos, has recently spoken at a conference about the use of AI in the judiciary, something that immediately would give me cause for a panic. But as we were talking about it last week, something does need to change with the capacity of the tribunals. I'll read you some of Sir Geoffrey's comments and his views, and I thought it'd be good for us to both kind of give our views in terms of what we see and the problems, but also, is there any advantages to that? So Sir Geoffrey noted that obviously there has been traditional scepticism within the judiciary about the use of AI. In my experience of a lot of the judiciary, there's scepticism about a lot of things that isn't their own views. But he's described AI as a tool that's like a helicopter or a chainsaw, which can be highly effective or dangerous depending on its use. A very master of the roles way of putting that. He acknowledged that AI could feasibly be used in areas such as assessing damages in personal injury claim and potentially reducing decision times from years to minutes. However, he cautioned against the wider use without careful consideration, citing 3 key concerns. 1, judicial decisions are society's last resort. 2, that machines cannot replicate human emotion, empathy, or insight. And 3, AI systems may be limited by the data and assumptions present at their time of development, which I actually do think are 3 sensible points. Separately to this, the courts minister, who is Sarah Sackman, has herself spoken positively about the potential in terms of use of AI in improving growth and access to justice. And there is a lot of, without getting political, there's been a lot of commentary about the government about the use of AI as an engineer for growth. So I think the law shouldn't be any different to that. So I just wanted to get your views, and I'll share mine on that, because as I say, that I think for me that first point Jeff made, that judicial decisions are society's last resort. I think if you went the complete Terminator 2, putting the AI in charge of the decision does seem absolutely alarming, because I think obviously last point for everything, even political decisions, if it's criminal matters, it's that the Supreme Court judgment is that would see absolutely alarming to me. I don't know what your general views are.
It's a difficult one, isn't it? Because I was discussing this at the weekend actually with my wife about electric cars, and I think our kids are a similar-ish age. I think our kids will say, "You drove a car with a petrol engine." And be completely astounded like that.
Or even you drove a car full stop.
Yeah. In the same way that paper files were sort of dying out as we came into practice. Now, this is a much different scenario to a paper file in an office, but part of me thinks, well, is it just progress? Is this something that should be welcomed if it can cut down? But then I don't know enough about how the AI arrives at a decision to be able to say, well, I think this is a good idea or not. I just think we've been using humans to make judicial decisions since the Romans. To upend that and say we're gonna use computers, I'm very uneasy about that. But I don't know. I don't know how that will work.
I think I share that. Generally, when I've been looking at AI and what we use, both profession and it's something I'm seeing all the time in practice. Grievances have now gone from 2 lines written on a piece of scrap paper to clearly a 5-page AI generated grievances. I think ultimately AI is the tool. It's a tool like the computer was a tool. And I think there is use that the judiciary would benefit from. So the example given in terms of assessing quantum in personal injury claims, I can see that being a tool that the judge would use, just as judges use their own clerks, their own research tools at the moment. And I can see that in terms of it being used as a tool, but still needing the human sense check. I would be uncomfortable in an employment setting for all remedy hearings to be dealt with by. So your judge deals with liability, makes the decision, unfair dismissal or not, and then both sides just submit ultimately their views on remedy to a bot that then decides the level of quantum, because it's still like human emotion. So let's talk about areas of law we know. So in employment, the point of mitigation is still there, and it would be very difficult for an AI bot to determine whether someone's attempt to get a job was reasonable or not. So that would be my view, but balanced again, as I said last week, something needs to be done, because equally it's not particularly good access to justice if people are waiting 3 years
for a decision.
plus for a decision. So I think it's positive that it's being discussed, but I think a lot of restrictions need to be put around it. And I actually can't really criticise or add a lot to those 3 points Geoffrey has made. Founded, as you would probably expect, but I think it's something that it isn't going away. And as I said, even in practice at the moment, we're seeing it all the time, both being used by companies to make decisions, recruitment a lot. You're seeing a lot of initial recruitment decisions being made by some form of AI, which itself has inherent in its algorithm can have prejudice within that. So I thought it'd be an interesting discussion, and we'll see what comes of it. I don't know if you've got anything else to add.
No, I think it's just let's keep an eye on it. There's going to be no facet of our lives that AI doesn't touch. So it'd be interesting to see how it develops, both for us and the judiciary and the courts generally.
I think the courts generally. I think so. It's not limited to employment. Will be interesting to see. In terms of out of the office, I think it would be remiss of us if we did not mention one of our favourite topics, obviously being rugby league, which is the restructure within Super League, adding obviously 3 new teams.
Yep.
And obviously congratulations to one of ours.
Yep.
On their Super League status, which was well deserved, and for Bradford, and great to see them back in the top flight. But yeah, interesting times within the league.
It is, and just on Bradford, I know Jason, Ian, Tracy, all the people at the Bulls have seen how hard they've worked over the last. We've been their legal partners now since 2022, and the journey that club has been on has been incredible. So it did not surprise me one little bit that they got into Super League. So really pleased for them. York as well, an expansion of Super League. It was York, wasn't it?
It was York.
Yeah. York and London missing out, which was quite surprising.
And then Toulouse.
And I think it reminds me of the early days of Super League when you had teams like Oldham and people like that, and it's got a real different feel to it now, which I think will be good. Be interesting to see how it pans out for the next couple of years. But yeah, congratulations to all 3 of those teams, in particular Jason, Tracy and Ian at the Bulls.
Fabulous. So I think that brings us a nice point to the end. Yep. Goodbye from me.
And from me.